Hello friends, welcome to Exam Tricks. This is Mangla Pandey and today we are going to deal with Article 16, Right to Equality of Opportunity. In this there are several subparts and we will try to explain each one of them. We will try to understand each one of them as clearly as possible. Article 16.1, we will start with it. It says that there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. It means that any appointment through the state are open to all, and to understand this you can imagine a race which is open to all, where everyone is free to participate. There is no restriction on any one of them, and hence it provides a kind of formal equality of opportunity. But if we are talking about a game, there must be certain rules for them, certain general rules which are applicable to everyone. That after then only it can be formal equality. So, Article 16.2 in a way provides rules of that game. What does it say? It says that no citizen shall be discriminated in respect of public employment by state only on the basis of religion, race, caste, sex, descent, place of birth, and residence, or any of. Here, focus on the word only. It states that discrimination will not be made only on these grounds. It means there can be certain valid grounds for which discrimination can be made. For example, in that game which we talked about, that race, everyone is free to participate. There are general rules for participation. But imagine a condition where certain class of people are not able to compete equally. For them, starting point is not equal because they are not getting equal nutrition, equal type of training. Therefore, the state, they need some extra support from the state to come and compete in the game. Therefore, Article 16.3 authorizes the Parliament to provide special favors in case of certain classes of public. And in this case, we can see in the example of the Mizo Accord in 1995, which granted special privilege to Mizo people. Again, certain extra favors are provided to people from certain states. For example, people from Jammu and Kashmir get reservation. These are few examples. But one thing you need to remember is that even if certain reservations are made by the state, the relevant law shall be passed by Parliament. It means that if certain laws exist under the Parliament, then only a state can enact a law under that law made by the Parliament and provide reservation. And again, if any such reservation is provided, it can be valid only for a certain period of time. It cannot be valid permanently. We will talk about the scope of clause 16.1 and 16.2 in detail later on. Let us move forward to Article 16.4. Article 16.4 empowers the state to provide by law reserving seats in public employment in favor of socially and economically backward classes of citizens. And to understand this, let us again relate it to that game. We talked about that formal equality of opportunity, and again some extra favors to some classes of people. But again, remember, certain classes of people who are socially and economically backward cannot even think of to come and participate. Therefore, the Parliament has got the authority from the Constitution to provide reservation to these socially and economically backward classes of people. But then again, Article 16.4 is just an enabling clause, which means that it does not confer a fundamental right on the backward classes. What does it mean? It means that if a state fails to provide reservation to backward classes of people, that then they cannot go to the court of law. But you can see in Indra Swahani versus Union of India case, Mandal case, Supreme Court upheld the validity of reservation of 27% of seats in public employment in favor of the OBCs. There is another subpart of Article 16.4, that is 16.4a, which provides provision for reservation for scheduled caste and scheduled tribe in cases of promotion. Although there was much controversy involved in this, and in 1997, Supreme Court held that under Article 16.4, reservation can be provided only at the time of recruitment and not at the time of reservation. But finally, in July 2014, Supreme Court withdrew that order and but made a condition that reservation in promotion can be provided to scheduled caste and scheduled tribe only if they are socially and economically backward, and the state ensures that they are inadequately represented in the employment. Before that, the Supreme Court also laid down constitutional requirements which are to be satisfied by reservation policy in order to be legally valid. You need not to do PhD in all these, but you just keep in mind the Supreme Court directives, because time and again questions come on the directives given by the Supreme Court on different issues. These grounds were laid down by the Supreme Court of India were: first, that the reservation will be provided only on the basis of social and educational backwardness; second, the state will ensure that the said classes of citizens are not adequately represented in public employment; third, it laid down the concept of creamy layer, and from time to time there has been revision of creamy layer. Committee was also set up to decide this layer, and we know that the definition of OBC is not been defined in the constitution, and it depends on the state to bring different classes of people under the level of OBCs. Again, the fourth, that the reservation should not generally exceed 50%, which means the reservation provided to OBCs under this 27% criteria should not exceed 50%. And finally, it also laid down the efficiency clause, which means that reservation can be provided, but it should not compromise with the efficiency. In 2001, Article 16.4b was introduced by the 81st Amendment Act, which added that carry forward rule in favor of scheduled castes and scheduled tribes will not be void even if it exceeds 50%, which means that even the said number of vacancies which were not filled in the current year can be carried forward to the next year, and even if it adds to the next year's vacancies and comes more than 50%, it would not be void to Article 16.1 or 2. Article 16.5 is another exception to that 16.1 and 16.2, and which prohibits appointment on the basis of religion. It provides appointment in religious denominations of person belonging to the same religion. For example, in Waqf board, people belonging to the same religion can be appointed, and it would not be void under Article 16.1 or 2. Now let us understand the scope of clause 1. It says that there shall be equality of opportunity for all citizens in matters relating to employment of appointment to any office under the state. It means that government is free, like other employers, to pick and choose from amongst the number of candidates offering themselves for employment under the government. It means that certain prerequisite conditions can be fixed for appointment, and the state is free to fix certain educational criteria, certain work experience, etc. for the appointment. Second, the equality of opportunity is not only important just because it provides a kind of legal equality. It is a mixture of both positive rights and negative rights. It not only provides equality of opportunity but also ensures that equality of opportunity can be availed. Therefore, it ensures not only the absence of disabilities but also the presence of abilities. Absence of disabilities in the form of non-discrimination, and presence of abilities in the form of affirmative actions through certain reservations. Finally, the third most important thing to remember is that The Article 16 is only an instance of the application of the general rule of equality laid down in Article 14, and it should be construed as such. It means that it ensures equality among equal classes of people. It means if it provides faster promotion to a guard than to the station master, it cannot be called discrimination because they do not belong to the same class of public. Thus, we can see that the scope of Article 16.1 is much broader than it appears. Now, let us come to the scope of Clause 2. Firstly, it prohibits discrimination on certain grounds. As we know, Article 16.2 provides non-discrimination on certain grounds, and therefore it assures the effective enforcement of right to equality of opportunity guaranteed by Clause 1. But earlier also we discussed that discrimination can be made on certain other valid grounds. Therefore, these valid grounds should be weighed in the light of general principles laid down in the Clause 1. Therefore, these grounds of discrimination are to be adjusted according to the Clause 1. Thus, it makes clear that scope of Clause 1 is broader than scope of Clause 2. Now let us move forward to the scope of Clause 3. We have seen that in Clause 2 residence cannot be a valid ground for discrimination, but in Clause 3 exception is made and residence can be made a valid ground for discrimination. However, one thing we should keep in mind that this condition can be made only by the parliament, which means that laws under this can be made only by the parliament and not by the state. Now, the most important part of Article 16 is Article 16.4, and the scope of this clause is much more broader than any of other clauses, because the word provision in this article mentions that nothing in this article shall prevent the state from making any provision from the reservation of appointments or posts in favor of any backward classes of citizens in which in the opinion of the state is not adequately represented in the services under the state. Here the word provision in clause 4 means that the state need not to make laws for providing reservation to the backward classes, and it can be provided only by any executive order. The parliament need not to go to its procedure, and the government itself can provide reservation in such matters. Then there is the Article 16.4a, which is just an enabling provision, where there is no constitutional duty on the state to provide reservation to the backward classes. Again, there is 16.4b, which tried to do away the rule of 50% reservation laid down by Supreme Court, which applied only to normal vacancies, not to the post of backlog of reserved vacancies. Another important thing in 16.4a is that it permits reservation in promotion for only scheduled caste and scheduled tribe and not for backward castes. Thus, finally, to conclude Article 16, we can say that Article 16 is just an expansion of Article 14, and Article 14 and Article 16 are supplementary to each other and have therefore should be read together. I hope you have enjoyed the discussion on Article 16. I will try to complete Article 17 and 18 in my next video, and in that video I will also discuss the type of question that could come from this section. Till then, bye bye. If you like my video,